about a duty of a banker, which is banking secrecy. As a banker, we should have a good faith and be able to implement our fiduciary duty, such as taking care of customers, details, and information. For example, their financial affairs, such as financial statements, their loans, and their personal information. It is important for us to not divulge any information to anyone, not even to the employer. Banking secrecy also can be seen in the cases of Tournier versus National, Provincial, and Union Bank of England. Let's see the cases is about what.
The National, Provincial, and Union Bank of England provide Tournier with an overdraft facility. He had made plans for making payment toward the overdraft reduction, but he had stopped making payment after only 3 installments. Tournier was the recipient of Woldingham Traders Limited checks. Rather than depositing the check in his personal bank account, he endorsed it to a London City and Midland Bank client. Because Woldingham was a customer, the defendant bank was aware of the check. When the manager saw the check provided for payment, he called the appropriate London City and Midland Bank branch to verify the customer identity. The endorsee was discovered to be a bookmaker who takes and pays out wagers. The manager then called Tournier's employers and spoke with 2 of the company directors. The exact specifics of the commission are unknown, although manager is said to have told them that Tournier was dealing with a bookmaker. As a result of such correspondence, the employers declined to renew Tournier employment contract. That's all from me. Thank you.
In this case, the bank informed the employer of his client that one of the customer unpaid check has been issued in best interest of the bookmaker's account. As a result, the client employer is unable to enter into a contract with the client. The Court of Appeal decided that confidentiality was an implied terms in the client contract and that any breach could result in damage liability if the loss occurred. So any information or document disclosed in connection with the customer account should be retained between the court and the parties to the proceeding, and no such parties should disclose such information or document to any other person. Except if the court orders otherwise, no one may publish the name, address, or photograph of any parties to the civil proceeding, or any information that is likely to lead to the identification of the parties to the proceeding, whether the proceedings are still ongoing or have been complete.
Solution for this case are: first, if a bank breached its responsibility by disclosing information, it should be held accountable under contract damage laws, compensating the client for all demonstrable harms originating directly from the breach, as well as indirect injuries that were reasonably foreseeable when the relationship began. When erroneous information is given, the bank should be held accountable for libel or slander, subject to the qualified privilege exception for information given in good faith to someone with an interest in the information. Second, the public interest clearly dictates that bank documents should not be made exempt from court order through the adoption of a privilege. Nonetheless, the bank should be required to follow a method for dealing with such requests that ensures utmost protection for each customer. The client should be told of the imminent inspection, and the request should be denied unless the customer concerns or a court or other entity with court order power authorize it. The bank should also demand proof of complete compliance with any legislative or juridically imposed requirement for collecting such information.
So, what is the duty of the bank that we can apply from this case? Well, the duty is called duty of secrecy. As we mentioned before, duty of secrecy is an agreement where the bank have the responsibility to keep their customer information secure, confidential and private. So the bank cannot reveal their customer information unless there is disclosed under compulsion of law, disclose is required in the public interest, disclose is in the interest of banks, and lastly, express and apply consent of the customers. So, what have we learned from this case? Well, the bankers need to be more aware when handling customer account and must divulge any customer privacy and private information to the third party. This is important because it can prevent the customers from experiencing any losses or issue that may occur just like this case. So, with this part, we have reached to the end of the presentation. So that's it, and thank you for watching.